Hi, the next section we're going to deal with in the client-lawyer relationship is the duty of confidentiality and confidential information. It's very important, it's very heavily tested, and to really summarize it, California says keep your mouth shut. So that's the California distinction that you should know right off the bat. Okay, so let's talk about the duty of confidentiality. As you know, attorneys owe their clients the duty of confidentiality. And a fundamental principle in the lawyer-client relationship is the lawyer may not reveal any information relating to the representation. So the lawyer can't tell his wife, can't tell his friends, can't tell anybody else about the client's personal confidential matters without the client's consent. Of course, when does the client can really consent to that? This confidentiality contributes to the trust that's the hallmark of the relationship. So the duty of confidentiality applies to all information relating to the representation, no matter where it came from, and it continues to apply even after the representation has ended. So, you know, if you look at the Johnny Cochran OJ case, Johnny Cochran could never reveal the fact that OJ told him he did it after the fact. You cannot do that. That's part of the duty of confidentiality. So the duty of confidentiality is extremely broad. When you think of the attorney-client privilege, it's more narrow. It's just an evidentiary testimonial exception that we'll get into. The duty of confidentiality applies to all information. It lasts to the end of time. It doesn't matter where you learned of the information, but it's protected. So you must keep a client's, you must not reveal a client's confidences, and it continues indefinitely. However, this is where you're going to be tested on, and of course you're going to be tested on the exceptions. Now a lawyer may, but they're not required to. So remember that. You may say something, but you're not required to say anything at any time. So the lawyer may reveal confidential information to the extent the lawyer reasonably believes is necessary. And in controversy between a lawyer and a client, we're going to get into each of these in a little bit more detail. The lawyer may reveal the client's confidences if death or serious bodily harm is likely to result. Also, the lawyer may reveal the client's confidences to prevent a client from committing a future crime or fraud that's reasonably certain to cause somebody serious financial loss, provided the lawyer's services were used to perpetrate the fraud. A lawyer may also reveal information to enable the victims of the fraud to mitigate their losses. Now, also the lawyer may reveal confidential information when the lawyer has to comply with a court order or another ethical rule. That means when false evidence has been introduced. In fact, this may turns into a must. We'll get into that in just a little bit. So the lawyer may say something when it comes to preventing death or bodily harm in a controversy between the lawyer and the client, and to prevent the client from committing a future crime that's likely to cause other substantial financial losses if the lawyer's services were used for that. Okay. So don't forget, a lawyer's decision not to disclose any of the above information does not violate the rule, the duty of confidentiality. A lawyer has no obligation to reveal any information in order to prevent harm. Thus, the attorney cannot commit an ethical violation for choosing to remain silent. The only exception to that is where the disclosure is required by another ethical rule or by a court order. And another ethical rule is when false evidence has been introduced. So anytime the client has perpetrated fraud on the court or the lawyer comes to know of evidence that was introduced that was false, the lawyer must rectify the situation. So they must reveal a little of the client's confidences. Actually, the lawyer should first explain to the client, hey, we need to fix this, and the client should do it himself. If the client refuses to fix the situation, then the lawyer must reveal it to make sure that they don't commit a fraud on the court. Because officers of the court, we have a duty to not undermine the integrity of the judicial process. So the duty to remedy false evidence actually trumps the duty of confidentiality. That's the one instance where the duty of confidentiality falls by the wayside. Okay, so let's take a look at the exceptions a little bit more closely. So in a controversy between a lawyer and a client, so the lawyer may reveal confidential information. In fact, you're putting the lawyer up against the wall when the client accuses the lawyer of misconduct, when the client sues the attorney for malpractice, or where the lawyer is attempting to collect a fee from the client. In this situation, the lawyer is going to have to reveal some information, but again, should not reveal too much information or unnecessary information. Limit it to what the claim is about. Okay, so that exception deals with disputes between the lawyer and the client. So the exception prevents death or bodily harm. The exception that permits a lawyer to disclose confidential information to prevent death or serious bodily harm recognizes the overriding value of life. Because life is so important that if the lawyer wants to save someone's life or prevent them from being in a coma for a long period of time, the lawyer may reveal it to prevent that from happening. Okay. Now, future crime if the lawyer's services were being used for that. So, if a lawyer discovers that a client has been using her services to commit a crime that is likely to cause others to suffer a substantial financial loss, the lawyer may disclose enough information about the fraud to prevent the crime or to enable the affected persons to mitigate their losses. So that's when the client has been using the lawyer's services to commit a fraud, causing other people to lose money. The lawyer may say something to prevent the people from losing money or for them to allow them to mitigate their harm. Okay, and the rationale for this exception is, since the client has been using the services to perpetrate the fraud, the client forfeits the protection of this rule. Now, for California, you actually have to keep your mouth shut on this one. You may not even reveal anything to prevent future crimes or fraud or to prevent others from mitigating their losses. California says no, they don't allow that, so you must keep your mouth. Again, California has strict confidentiality requirements. Now, in California's duty of confidentiality is found in the attorney's oath, and it states the attorney must maintain inviolate the confidences that every pearl to himself, the secrets of his client. That means the same thing. It's just language that you don't need to memorize. It's just in the attorney's oath. It's under the Business and Professions Code. Again, California does not have an exception for financial crimes. Therefore, a lawyer is prohibited from revealing any information that has to do with a crime or fraud, future crime or fraud. Okay. Now, one other thing too is before revealing confidential information, the lawyer should first seek to persuade the client not to commit the act in question. Hey, stop ripping these people off. Don't kill this person. Don't kill your wife. Although that's a really hard one to sell. So you must persuade the client not to commit the act in question. And then you should explain to the client that the lawyer has the ability to reveal such information. Again, in California, it's most likely to be for death and serious bodily harm. And when the lawyer does reveal such information, disclosure should be no greater than necessary to accomplish the purpose. Again, disclosure is ordinarily a last resort. Of course, so the lawyer should persuade the client not to do it, explain to the client his or hers, the lawyer's responsibilities, ethical responsibilities, maybe possibly withdraw, and possibly reveal enough information to rectify the matter. And again, disclosure should be no greater than necessary. Well, but as I've been saying, you have no obligation to speak. Now, so a lawyer's decision not to disclose any of the above information does not violate the duty of confidentiality. A lawyer has no obligation to reveal any information except, as we mentioned, where the disclosure is required by another ethical rule. Okay. So that goes for the duty of confidentiality. We can move out of that, and let's go to inadvertent disclosure. You just have to reasonably prevent others from disclosing a client's confidential information. So all that requires is a lawyer must make reasonable efforts to prevent the inadvertent disclosure of confidential information. This, again, is part of the duty of confidentiality. It's not really a big topic. It's just something to kind of, like a footnote to it. Okay, now the attorney-client privilege. This is where a lot of students get confused between the attorney-client privilege and the duty of confidentiality. Think of the duty of confidentiality as this broad spectrum where you just can't say anything to anybody about the client's case. Whereas the attorney-client privilege, it's a testimonial privilege, which means it's going to apply in any judicial proceeding where the lawyer is going to be called as a witness and compelled to testify against the client. The lawyer can say, hey, I'm asserting the attorney-client privilege. Of course, the client can also prevent the attorney from testifying. This privilege is actually evidence. You'll get it in the evidence outline, but we're going to cover it here just because it coincides with the duty of confidentiality. And most likely it's going to apply at trial, because again, it has to be in a judicial proceeding. And I'm going to read to you exactly what you need to know. So the attorney-client privilege, including the work product doctrine, applies in judicial proceedings in which the lawyer may be called as a witness or where evidence concerning a client is sought from the attorney through compulsion of law. That means the attorney gets subpoenaed to testify or subpoenaed to bring in documents that are going to incriminate the attorney, the witness, or the client, excuse me. The attorney-client privilege is a testimonial privilege. That means it has to do with the lawyer testifying against the client. And it mainly applies at trial. So that's why it's going to be in evidence. That's why you're going to see it in evidence. And it allows the client to prevent his attorney from testifying against him. In comparison, the duty of confidentiality is a much broader and applies to all information regarding the representation, and has nothing to do with being called as a witness in a judicial proceeding. Again, the duty of confidentiality prevents the lawyer from talking to friends, family, anybody else about the client's case. Okay, it's the client's case, leave it between the client and the lawyer, don't tell anyone else, okay? Again, attorney-client privilege is covered more in depth in the evidence outline. And finally, when we have a corporate client, when the corporation is the client. So just remember, when the corporation is the client, the lawyer represents the corporation and must proceed in the corporation's best interest. So if the lawyer knows that a person who works for the corporation is engaged in an illegal act, the lawyer must proceed in the best interest of the organization. And generally that means refer to a higher authority. So if you have like an employee committing an ethical violation that's likely to cause substantial injury to the corporation, you should probably tell the president of the corporation or a manager or somebody who's in a higher up position that can take care of the matter. And if that doesn't work, then if referring it to a higher, the attorney must refer the matter to a higher authority, generally the president of the company. But if the highest authority that can act on behalf of the corporation, that's generally the board of directors, because they're the owners. I'm sorry, no, not the owners. The board of directors controls everything within the corporation. So if the highest authority refuses to act in an appropriate manner, so let's say the company is distributing toxic waste into the streams, and you know that the president is doing that, you tell the board of directors, and the board of directors refuses to do anything, then the lawyer may report the violation outside of the organization without breaching the duty of confidentiality. So the lawyer may tell the Environmental Protection Agency, hey, this company is actually putting toxic chemicals into the water where it's likely to cause death or substantial bodily harm. Now, California says, no, you may not. California prohibits outside reporting. Again, so they want you to keep everything in-house. California has strict confidentiality requirements. But then again, California allows you to reveal something about death or bodily harm, so generally California does prohibit outside reporting. So if the company's committing financial crimes, you gotta keep your mouth shut in California. Okay, and that is a wrap for that. Oh, and also, when you're dealing with an employee of the corporation, you have to explain to the employee that hey, I represent the corporation, they're my client. And if your interests are adverse to the corporation, I can't represent you, and you should probably seek your own attorney. And also, anything you and I talk about, it's not privileged because I'm not your attorney, I'm an attorney for the corporation. So that's why you have to have that sit-down discussion, because again, the employees don't understand. They look at you like, oh, you're my attorney too. You're not, and you must clarify that position. Okay, and that's a wrap for Section B, the client-lawyer relationship that deals with the duty of confidentiality.